Morning. Good morning. Please be seated. All right. Good morning. Ms. Moore, good morning. Thank you for joining us. Anything can't hear me or the lawyers who are speaking or anything else that's going on, if you could just interrupt us, that would be really great.
Absolutely. Thank you, Judge.
Thank you, ma'am. All right. Good morning. Today is December 5th, 2025. This is the time and date set for a series of hearings on motions in the matter of David Krieger et al. Versus the Michigan Department of Environment, Great Lakes and Energy et al. The lead case number is Court of Claims Case 20-94MM. I'm Judge Redford. I'm the judge presiding over this case. If we could have appearances first for plaintiff's counsel and then for defendant's counsel.
Sharon Almond Road for Mass Plaintiffs.
Good morning, Your Honor.
I didn't see it. It's all right. I'm sorry. Gosh, your voice is, I'm looking at the screen after I just had 2 days of, we had 30 cases on our case call this week. So I'm hearing voices from everywhere. So at any rate, thank you, Ms. Almond. Good morning.
Good morning, Your Honor. Kevin Carlson for Mass Plaintiffs.
Good morning, Your Honor. Jason Thompson and Paulina Kennedy for the class.
Okay.
Your Honor, Nathan Gamble here on behalf of the defendants.
And Richard Cole also on behalf of the defendants.
And Nathan Frischkorn on behalf of the defendants.
Sir, how do you spell your last name?
Frischkorn.
Thank you. All right. Okay, let me just get my computer, make sure it's up and running correctly. All right, we have 5 motions set for today. And what I'd like to do is just sort of indicate how I plan on proceeding this morning. And I hopefully just this morning, but if we need to go into the afternoon, we'll go into the afternoon. We have 5 motions that have been filed. They're going to be heard in the following order because of the date and time that they were filed. We're just first in, first out is the methodology. It's the extent of the science involved and why we're taking them in this order. First, it'll be September 5th, 2025, defendant's motion eliminate to bar evidence regarding the 5/28/2019 ruling of the circuit court. This relates to lake level. Arguing for defendants will be Richard Cool. Arguing for plaintiffs will be Sharon Almond Road. Second case, so the second motion filed October 3rd, 2025 is plaintiff's motion to exclude the independent forensic team report for plaintiffs, Mr. Carlson, for defendants, Mr. Gamble. Third, and in these 3, 4, and 5, I'll be saying what time in addition to date they were received because all 3 were received on November 21st, 2025. The third motion we'll hear is plaintiff's motion eliminate to exclude expert opinion testimony from non-retained independent forensic team members for plaintiffs, Mr. Carlson, for defendants, Mr. Gamble. This was filed November 21st, 2025 at 2:11 p.m. The next motion will be defendant's motion eliminate to preclude testimony of governmental inaction filed November 21st, 2025 at 4:08 p.m. for defendants, Mr. Frischkorn, for plaintiffs, Mr. Thompson. And the fifth motion is defendant's motion eliminate or preclude testimony based on Dr. David Williams model, November 21st, 2025 at 4:11 p.m. Mr. Cool for defendants, Mr. Carlson for plaintiffs. That's the extent of the motions that I'm aware that we have to address. Is anybody here for the plaintiffs aware of any other motions?
We are not aware of any other motions, Your Honor.
No, Your Honor.
Defense?
No, Your Honor.
Okay, so what I would anticipate is we're going to go through the motions in the literal sense, not in the pejorative sense. We're going to go address the motions. Each side will have, each moving party and responding party on each motion will have not more than 15 minutes. You don't need to use it all. I've read all the pleadings. I've read many, if not, I haven't read all of the cases you've cited. I've reviewed, I don't think you'll need it. Certainly on some of them, I don't think you'll need it, but that's up to the individual counsel. But once we hit 15 minutes, then you're done. If you're the moving party, if you want to reserve for a couple of minutes, not more than 3 for rebuttal, let me know when we get started. I'll try to keep track. I'm not, in one of our, well, I will do my best to keep track of the time correctly. Suffice it to say, how much time a trial court took to do certain things in a certain case became a matter of some import this past week in some cases that I was reviewing. So for the Court of Appeals, if you're reviewing it and you say, Redford, you said you were going to give him 15 minutes, but you only gave him 13 and a half, and you gave the other guys 16 and a half. I'm really not trying to favor anybody. I say that only because it's very fresh in my mind about the arguments and the discussions and the impact of it. The lawyers have had, anyway, so we'll do that. We'll get through, we'll address the 5 motions. I do not intend to rule today. I intend to issue a relatively brief opinion and order addressing all 5 motions by Thursday, of the end of business on Thursday of this next week. So that the parties can be prepared for our final pretrial conference on January 5th and for the commencement of the trial on January 12th. Once we're done addressing the motions, I'll then open up the table for discussion about if lawyers have questions, concerns, if we want to address housekeeping matters for purposes of, as we get closer, we're, 1 month and 4 days away from, well, more, whatever, we're right just over a month from trial. So I suspect we'll be spending a lot of time together in January and probably February. So if we need to talk about some logistical things and things along those lines, I'm very happy to do that and would plan to do that. We're starting at 8:30. I would expect we're going to take a morning recess at sometime between 10 and 10:30 for about 10 to 15 minutes, depending upon where I'm at that point. We're going to keep the same trial basically we would as if we're keep the same schedule as we're likely to in trial. So, all right. Any questions from plaintiffs before we get started?
No, Your Honor.
Defense? Okay, fine. It's Mr. Cool, you may proceed.
Good morning, Your Honor. Assistant
Morning.
Attorney General Richard Cole on behalf of the state defendants. I'd like to reserve 3 minutes of my time. I don't think I'm going to need all 15 minutes, but I've said that before and been wrong. I want to be clear. This is not a motion to bar evidence of the May 28, 2019 order. This is to us, that this is a critical document. We intend to rely heavily on it in our case. What this is a motion in limine to bar plaintiffs from submitting evidence that contradicts the finding of that circuit court. That was an action that was brought by Gladwin County, Midland County, and the Four Lakes Task Force. And the very purpose of that action was to set under the Inland Lake Level Act, the normal lake level. Under that act, the normal lake level is defined, among other things, as that level which best protects public health, safety, and welfare. Notices of this proceedings were sent to thousands of individuals living on or that had egress to the lake. Newspaper notices were published throughout the county's Facebook pages. Meetings were held about this. The court held a hearing in which it took testimony about what should the normal lake level be. All of the sorry, go ahead.
When did FERC hold the license?
It would have been before this date. Was it 2018?
September 2018.
And that's why the county stepped in, right? They knew that work had to be done. They knew that they wanted to maintain the levels of the lake, so they filed this action. This is an action that allows them to identify what is the best normal lake level. And so they filed this action. They had a hearing. Anybody that was interested, all interested parties had the right to participate in that, and many did. And on May 28, 2019, the court entered an order making findings of facts about what the normal lake level for Wixom Lake should be. And the reason this order is important is, for today's purposes, is because all of the plaintiffs in this case, all of the plaintiffs were either parties to that litigation or in privity with a party such that that May 28, 2019 order is binding on them. All of the residents.
So let me ask you a question. If after the order is entered on May 28th, 2019, if state agents become aware of all manner of evidence which informs to them that this level is not safe, why shouldn't, why can't there be discussions about this lake level? Why is it res judicata? Why is it collateral estoppel? Why is it not relevant?
I think you can say, first of all, if they're just going to argue this normal lake level was not safe when the state took it over, they can't do that. If you're going to look at specific evidence after that date, maybe they can make that argument. But their argument from the beginning has been that just setting at that level, the normal summer lake level, was dangerous. But that is exactly contrary to the position they took in that circuit court action.
But why doesn't the fact that they took that opposite position, if that is in fact what took place, why isn't that just as admissible as a setting of the level from this defendant's perspective to say, hey, listen, you're saying all these bad things, but you're the parties that advocated. You had this confederation of interested parties that were interested in keeping the space as a robust recreational area. And you all are the ones that drove this. Why can't the state use that evidence in defense of the plaintiff's claims that it was the state acting improperly, inversely condemned the properties?
Sorry, I'm a little bit confused by that question. We believe,
Super long question, so that was part of the problem, but.
yeah, I think up until the time of that order, there's no questions. Plaintiffs were asserting our stop from arguing that normal summer lake level was safe. That's clear. Did I get that backwards? Up to that point. So if they want to show maybe there was some evidence after that point that the state became aware of, that the state knew of, and so the state took some action based on that information, that's an issue. Again, we're not trying to preclude their defense. We're just trying to narrow the issues for purposes of trial.
But on what legal basis? Is it collateral estoppel? Is it
Yes.
res judicata?
Collateral stop.
All right. So for collateral estoppel to apply under the Monade case versus State Farm, there has to be a question of fact essential to the judgment was actually litigated and determined by a valid and final judgment. The same parties must have had full and fair opportunity to litigate the issue. There must be mutuality of estoppel unless the defense of collateral estoppel is being asserted defensively against a party who has already had a full and fair opportunity to relitigate the issue. So how do you meet all those thresholds?
Was it, that was the very issue. First of all, the first issue, was it contested? That was the key issue for that hearing. What should the normal lake level be? There's no doubt that was the issue. Was there a full and fair hearing? Absolutely. As I said, everybody got notice. The court held an open hearing. All interested parties were invited and were able to participate. It's not that they did under due process. It's just that they had the opportunity to participate. So we meet that. And with respect to mutuality, because it's a defensive assertion, it's only binding on the plaintiffs. We don't have to be a party to that proceeding. So we go through each of the elements in our brief. I think clearly we do meet all of those elements. I didn't intend to take up a lot of time here today. We think it's only fair. We have a circuit court order. The integrity of that order should be protected. And in that order, the findings of that court were sought by the plaintiffs. They can't now disavow those. So we'd ask you to order the relief that we've requested.
All right. Thank you.
Thank you.
Appreciate it. Ms. Road.
Let me get this a little bit closer. I have a little bit of laryngitis today, so I
Sorry
apologize.
to hear that. I hope it's not too discomforting.
No, I'm fine. I just apologize for my voice. Basically, we've laid out three primary reasons why the motion should be denied. It's a procedural impropriety. They've waived it. They can't meet their burden. And substantively, it fails. They filed this as a motion in limine, but it's actually a motion for partial summary disposition. And that has already, and they can't use a motion in limine as a bludgeon to eliminate an entire claim, which is essentially what they're attempting to do here. If you, Prenducci versus Farmers Insurance Exchange, it's an unpublished 2015 Michigan Court of Appeals decision, explicitly rejected a motion in limine filed on the eve of trial to exclude, for example, damages, and they claimed it was as evidence.
What's the
And-
case, please?
Prenducci, Prendushi.
Is that in your
I
responsive brief?
thought it was. I don't have the actual brief in front of me, but I can provide a citation. The trial court called,
What's the citation? Because I don't see it.
I don't have it in front of me right now, but I can provide it.
Prenducci.
Prenducci, Prendushi.
Before we leave for the day, if you could let us have
I will
that.
do that. The trial court called it explicitly a disguised untimely motion for summary disposition in that case. This is a federal,
Why do you think this is a motion for summary disposition?
because they're asking for that to be dispositive, that in this case as to water levels and not being able to litigate it, to litigate the water levels. And in this case, that the safety of the dam, there was a 20-minute hearing, and in reading the transcript and otherwise, the safety of the dam or the safety of the water level was really never litigated in that.
Right, but counsel, they had the opportunity to, but they chose not to. There were all sorts of parties who said, you know, we really want this lake level to be at X. If all of the individuals who were subsequently injured as a result of the failure of the dam had chosen to do so, what prevented them from asserting, hey, listen, this thing doesn't pass half ppm. This thing is a hazard. The previous owners really didn't do it very well. The spillway is not big enough. Judge, you can't do this. I mean, what kept them from doing it?
The concealment that these issues were not.
Matters of public record, counsel. It was a matter of public record that the spillway was smaller. That was in their petition to create the Four Lakes Task Force.
But it was not in our client's position. We represent approximately 2,000 people in Mass. Class has, I believe, approximately 10,000 people, and they were not parties to this. They were not privy to this
They
action.
all were on notice of the hearing, correct?
That isn't established, and they had, if it's an affirmative defense, the burden is on the defendants to come forward with evidence that all of these
They're
people were
not
on
saying
notice.
it's an affirmative defense. They're saying you're collaterally stopped from arguing this.
Well, our clients were not parties, that they were not in parties.
You don't
with it.
have to be a party. You have to have the opportunity to be a party.
But-
Which of the what plaintiff that you represent did not have the opportunity to be a participant in that litigation?
They were not fully informed because of the concealment of the condition of the dam. So they
So-
certainly didn't have a full and fair opportunity to participate.
You misunderstand my question. Under the notice provisions of Michigan law, for a Part 307 hearing, which of your clients, a client, give me the name of a person or business who claims to have been damaged, who did not receive the notice required under Michigan law?
I can't speak to that without surveying all our clients for certain.
Well, this is the day.
We did not go out and survey our 2,000 clients to find out who did or did not receive a notice.
So the answer is you have no indication of anyone.
I can't
Correct.
present a specific person here today. No, I cannot. Michigan courts have held, though, that Part 307 doesn't create a civil cause of action for individuals. And if you can't control the proceedings, it's unfair for our clients to be bound by that proceeding now. They have no say in those proceedings. It violates the due process clause to bind a litigant to a judgment in a case where they are not a party and not adequately represented.
Well, it does. If that were so, counsel, then the jurisprudence of Michigan's collateral estoppel and res judicata laws would be not 180 degrees different, but it would be 90 degrees different than it is today. The binding precedent is that the party has the opportunity to participate. And for whatever reason, they don't. But if they are,
I don't think it's established that they're in privity with these people. I think that's where the stretch is, to suggest that our clients are really in privity with the people that were the petitioners and had the same interest. There's no evidence that they were in privity, which is a requirement for collateral estoppel.
if you're in this universe of property owners who are required to give notice and there's no evidence of record that they didn't receive it, I don't.
Is the court's, the burden is on the defendants to show that these people actually received it. The burden is defendants, and they've raised this defense untimely, and the burden is on them to meet that and to present evidence. And they have not presented evidence that all of these people had notice.
What from the lake level do the plaintiffs wish to bring to the court to meet their burden of proof? If you're allowed to use this, what are you gonna show?
We're going to show partly that there was concealment, that there was not an adequate there was not a discussion of safety at that time and the safety issues.
How are you doing that? What witness is gonna say that?
We're going to demonstrate that in part through Mr. Sturdivant, who already testified about that, through, we believe through the adverse parties when they're called, their testimony, They're not going to admit it in the manner and form I stated, but certainly they're going to have to discuss what went on in that hearing. And the hearing and the papers do not show that there was a fulsome discussion of the safety of that dam.
My recollection is there's some entity called the Spicer Group. Is that right?
Yes, there is.
And they were some type of engineering firm,
Yes,
or maybe are. I don't know if they.
they are, Your Honor.
At the time, I'm speaking in the past tense. And they, we've all been together in this since late January, early February 2024. So been a lot of discussions, but my recollection is they provided some testimony to the court. Is that your recollection?
Yes, they did. And none of it involved the PMF or any discussion of the hazard that this posed to the public.
Are they endorsed as witnesses?
We are not presenting them.
That's not what I asked. Are they endorsed as a witness? Someone from the Spicer Group?
At the 307 hearing.
No, for
Here.
this trial.
I believe that defendants have listed them.
All right. And then from that evidence that you would seek to solicit either through the cross-examination of the opposing parties' witnesses or through presentation of your own testimony through Mr. Sturdivant, that's what you're seeking to show. Use it to show that really that historic lake level that was adopted by the circuit court was either incorrect, of no moment, or nefariously obtained.
I think of no moment, and ultimately in this case of no moment, and certainly obtained without full information.
You don't disagree, I'm assuming, but we all know the old adage from grade school, what happens when we assume. I would think, let's assume that the court were to deny the defendant's motion. What is your position if they establish that this Part 307 order was entered? Do you agree that it will be permissible for them to use that as one of their arguments for why you have not met your burden?
I believe that could be, but Your Honor, as you pointed out in your questioning of Mr. Cole, that would not obviate the Eagle's responsibilities as new information became available.
Right. Well, I'm not trying to point out anything in my questions of counsel. And that actually leads to it. I have read with great interest, more so in this case than in any in my over 2 decades of experience, how frequently both sides take questions or statements of the court and then convert them into it is the position of the court or the argument of the court. It's disquieting. I just observe that both sides have done it on a regular basis. You just did it. And don't feel like I'm picking on just you. It's something that many pleadings have demonstrated, many arguments have. And it's something I am unaccustomed to in all the time. I've had a chance to be a civilian or military judge, but.
Your Honor, I did
No,
not.
please, no,
I'm sorry.
I'm just making an observation. And I'm not Not seeking any input from you on that. Okay, I understand your position so far. What else you want to share with the court? You have 2 minutes remaining.
I keep talking about the burden of proof under Palankas versus Beaumont. Defendant bears the burden of producing evidence to support the defense. If the 307 proceeding is considered to be dispositive, it would be dispositive of a claim potentially. It certainly is an affirmative defense under all of the case law.
I understand your position. Anything else?
No.
All right, thank you, Ms. Olmenroad. Mr. Cool, I guess my first question, let me set my timer. When you preside in Detroit, in the Court of Appeals, they have I was never a basketball official, but it looks like that. I mean, you hit a button and the thing starts rolling. It's so much easier. I'm using my iPhone. So, and if anybody wants an affidavit for any of my 3 children about how I am not very good technology wise, either they or any of my former or current law clerks could provide one to you too. So, but I'll get started. All right. So what you want the plaintiffs to not even be able to argue about the lake level. Is that right?
And again, it's for any time up until that order, they can't argue the day that May 28, 2019. They can't argue that the normal slum level was safe. After that point, if they have,
Can't argue that it was not safe.
correct.
Oh, okay.
Sorry, there's too many
No,
double
I-
negatives
no,
there.
there's-
It's a problem. If they find something after that date, which Eagle knew and Eagle took some action based upon, that would create an inverse condemnation, yes, they can rely on that. We are not seeking to preclude any. I'm not quite sure how the argument was made that we are seeking to preclude a count. That's not true. They didn't even really explain what count they were saying this would create a preclusive effect on. We're just trying to, all our motions today are trying to narrow the issues for trial. So we're not here for a month in January. No disrespect to your honor.
It's only a month in January. I declare that a enormous victory of efficiency for all the lawyers in the court.
Well, that's what we're hoping to do. And that's why really what our motions are directed toward today. The argument was.
But if they have some evidence that suggests that some person who worked for one of the defendant agencies or departments was aware that the spillways or that the dam didn't reach the half of the probable maximum flood. I mean, why shouldn't they be able to argue, A, introduce that, okay? And B, then argue, Judge, this 307 is of no moment. They didn't share what they had. It's not fair. I mean, what's your position?
Well, they haven't offered any of that evidence.
Well, I think
Not
they have
in
in their
response to
arguments.
not in response to our motion, they have not. Again, the inadequate spillway was known, right? It was part of the petition. It was discussed at the 4-hour hearing, not 20-minute hearing. It was discussed in the Spicer report. Everybody knew about it. That's why they pulled together the 4-Lace task force so they could assess the property owners to fix the problem. They had a schedule to fix the problem.
Right. Okay.
So
We're at
we think
time,
Your Honor
so-
gets the issues.
I hope I do.
Um,
At this
so-
point, I sure hope I do. But
We appreciate your
thank
time
you.
and
Okay. All
consideration.
right. Thank you.
Thank you.
All right, thank you. That matter is submitted. Next motion is plaintiff's motion to exclude the independent forensic team report. On behalf of plaintiffs will be Mr. Carlson.
Yes, Your Honor. I am going to keep my time and reserve the 3 minutes for rebuttal just so I can see it. I'm used to arguing appeals too. So Okay, thank you, Your Honor. This is the plaintiff's motion to exclude the opinion, the testimonial hearsay and opinion portion of the independent forensics team report.
Are you simultaneously filing a motion to withdraw Mr. Sturtevant as one of your witnesses?
No,
Okay, then I'm very curious on how he gets to testify.
I will get there promptly. Okay,
Good, because that's the,
right.
and there's one of your colleagues wrote something I thought was so interesting. So helpful to me. At page 3 of plaintiff's response in opposition to a different motion with regards to Dr. David Williams, page 3, the plaintiffs say, quote, "That principle applies here with even more force since this is a bench trial. The court does not need protection from competing expert opinions. It needs access to them." What an interesting position to take. And then later it says that page 4 and 5, explaining why certain things should be admitted from their perspective. Manual specifies the structure of HMS models, describing how the hydrological elements are components, such as subbasins, reaches, and reservoirs, et cetera, et cetera. I just, when each side is seeking the relief they want, they say, yo, don't consider this, don't consider this. When they're seeking, no, we want to introduce it, that everybody, both positions are, no, the court needs it. How does Mr. Sturtevant get to testify if the document that you seek exclusion of is not allowed?
Yeah, Your Honor, I appreciate this concern, and I understand and I fully appreciate the notion here that appears we're trying to thread a very narrow needle or walk an extremely fine line between and straddle both sides as to what should come in for Williams but not come in for IFT. But here's my best take on the distinction, okay? The IFT report itself contains two different kinds of materials. It contains raw facts and data, things like lake levels, boring logs, lab results, geometric field measurements. All of that factual information is undisputedly admissible, and it's all discoverable. The IFT report also contains opinions, analyses, deliberative conclusions by engineers. None of that has been disclosed, and it is not discoverable in this case.
Why? I have heard your side of the case say it's not discoverable for nearly 2 years.
Right.
And I've been lectured and had argued to me, oh, there are these federal things and there's this and that, and they're not available. And I said it over a year ago. There are principles called the TUI regulations. They directly impact the manner in which a litigant can seek to obtain information from a federal agent. I know this because I was a federal prosecutor for 8 years with the U.S. Department of Justice, a Navy judge advocate for 28 years, 6 of those years handling the civil litigation of a non-tort nature for the United States Navy at the headquarters of the Judge Advocate General's Corps of the U.S. Navy at the Washington Navy Yard. Every federal litigator is familiar with these. I keep reading about how to seek this information, if we were at the periodic table, it would be the element unobtainium. And that is simply not what it is. So why? I have never been asked to provide the court's assistance to seeking a party to testify through a subpoena that I'm aware of. Do you have either I or any of my predecessors were assigned the trial judge in this case, been asked by the plaintiffs to compel some federal representative or agent to submit to a discovery deposition?
To my knowledge, no.
All right. If that has not taken place, then how is it an accurate statement to say we're not able to get the discovery?
Because we've served the witnesses, the 5 IFT members, and also the companies like AECom and others that provided information to be used by those IFT members in the deliberative process, the modeling and the things like that that they would have used. We don't know if they used HEC HMS. We don't know if they used HEC RAS. We don't know if they devised their own model
You
for,
never deposed them.
we tried, and FERC stepped in.
You did not bring that to the court's attention and seek judicial assistance, which would then automatically have been removed to my friends across the street at 110 Michigan. The federal government would have come in and said, we make a motion to remove. The subpoena issue would have been removed to the federal district court, and you would have litigated it. How can you, on a month and 10 days before the trial starts, having never sought the judicial assistance to compel the discovery, how does that become a basis to exclude a whole body of evidence?
Well, that is one basis, Your Honor. That's part of the basis for exclusion. I appreciate the court's concern that we could have done more to press for court intervention or
Well, you didn't do
compulsion
anything,
to do it.
counsel,
Well,
did you?
we interacted with counsel for FERC to try to resolve their objections, which they would not withdraw. They stood on those
As far as I
objections.
understand, counsel for FERC does not have the authority of the Constitution of the state of Michigan and the statutes which create this court to order compliance with the court's orders. Fair?
Fair, Your Honor. I don't know the
Okay.
answer to that question. I think you know it better than me. I would defer to you on that.
I don't know if they would have, I don't know. I do not know, and I want to make sure the reviewing tribunals that will review this case undoubtedly, I am speaking to the appellate record right now for a moment. I am not saying and making decisions based on, I'm certain that this, that, or the other thing would have happened if they would have subpoenaed them, if the TUI regs would have been followed. And I'm not trying to substitute myself as trial counsel for either side. Lord knows I had the privilege of doing that long enough, and I do not seek that privilege any longer. And I'm not trying to advocate on behalf of either side, but what I am trying to do is to determine whether or not certain evidence should be allowed or not allowed. And when a party says we haven't been able to take discovery, and I've never been asked, there's never been a motion to compel or anything else, I just want to make sure the reviewing tribunal understands none of my words are meant to be construed as disrespectful or discourteous. I don't mean to be disrespectful or discourteous to any of the lawyers who are appearing. I know they're all trying very hard in a substantial and complex case. But I also think it's important that we understand what has happened in the litigation thus far. And now we're seeking to exclude a report. And one of the bases is, as was argued by counsel, and that's why I asked the questions that I did.
Your Honor, yeah, so the additional reason for the report itself, I mean, take Bill Sturdivant as an example. If plaintiffs were to say, you know, we've chosen not to call Mr. Sturdivant for testimony in this trial, we merely want to offer his expert report as substantive evidence, the court would swiftly say, no, it's inadmissible hearsay. An expert testifies through their live testimony at trial, and
So our Michigan rules of evidence require that which an expert relies on is admitted,
right.
admitted, not admissible, admitted. I remember when the rule changed.
Yeah, so it doesn't have to be admitted into evidence pre-trial. It can even be admitted after the witness testifies. That's the,
And I'm not going to rule today, oh yeah, the report comes in. That's
Yeah.
not the ruling, but you're trying to keep it out prophylactically.
the opinion, the hearsay, testimonial opinion and conclusion portion of the report, Your Honor. And the guidance for that comes from the Michigan Supreme Court's decision in People versus Fackelman, Fackelman. The citation is 489 Mich 515. And in Fackelman, it was a criminal case where there was a prosecution expert psychiatrist, a defense expert psychiatrist, And one party wanted to break the tie by using the report of a treating psychiatrist named Dr. Shahid, including Dr. Shahid's diagnosis. And what the Michigan Supreme Court held at pages 562 to 563 of Fackelman was that Dr. Shahid's diagnosis was not admissible in evidence in the trial because it was hearsay, and Dr. Shahid himself did not appear to testify. And the
What's the
court,
nature of the allegation in the criminal case?
the allegation in the criminal case was the plaintiff's, the defendant's son had been killed through an act that was attributable to the victim. The defendant in the criminal case went to what would have been his deceased son's first varsity baseball game and tailspinned into emotion and regret. The man had a breakdown. In the throes of that breakdown, he went to the victim's house, the victim who he blamed for his son's death, and attacked him. And so the psychiatrists were saying, what was his state of mind when he
Thank you.
undertook that act? And so Dr. Shahid was the treating psychiatrist at the time, but Dr. Shahid didn't come to the criminal case to testify. They just wanted Dr. Shahid's diagnosis from his original report at the time of treatment to come in.
Did whoever proffered the report rely on that report?
Yes. And it was the reason why this case was reversed by the Michigan Supreme Court, because it was the only evidence that spoke to state of mind at the time of the incident. And so the Michigan Supreme Court said that under MRE 703, only the facts and data contained in Dr. Shahid's report were admissible. The diagnosis was
So you
not
agree
admissible.
that of the IFT report, all the facts and data are admissible?
Yes.
Okay.
And continuing, Fackelman said the diagnosis was not admissible because it was opinion. The jury should have been instructed that the proper and limited purpose of Dr. Shahid's report was to allow them to consider the facts and data on which the testifying experts had based their conclusions. And so in this case, you have experts who look at the
I mean, counsel, we were all here together that happy day in September for hours, listening to Mr. Sturdivant, who seems to be a remarkably bright and gifted individual. I enjoyed that day immensely. But time and time again, in both his live court testimony and in his depositions, he talks about the Four Lakes Task Force. And I don't know that he uses as fine a cut of the scalpel to narrow his observations of it, as you suggest the Supreme Court did in the comparison of these expert reports.
Yeah, in terms of presenting his testimony,
And you're already down to 2 minutes rebuttal if you want to.
I'm past that, Your Honor. I will say it will be our job to navigate which facts and data are extracted from which source as the foundation for opinions in the trial. Will be prepared to do that. But I think that the diagnosis, the conclusions, the testimonial hearsay from the 5 witnesses who have not submitted expert reports or claimed authorship of the various pieces of this opinion should be inadmissible.
All right. Thank you.
Yeah, Your Honor, I think that also covers our position with respect to the next motion on the docket today, which is the IFT witnesses. The IFT was composed of 5.
We're not on that motion, counsel.
Oh, I think it's next on the, oh,
It is.
they get to respond next.
Yeah.
Why am I talking out of turn?
I don't know, but you have 1 minute and 15 seconds
Save
remaining.
that time. Thank you.
So thank you. But thank you for your enthusiasm.
Morning, Your Honor. Nathan Gamble on behalf of the defendants. I wish to emphasize that the position that opposing counsel just took is new. Their written motion in which they sought to exclude the report explicitly characterized the entire report as inadmissible hearsay and explicitly requests in their conclusion that the entire report be excluded. And so now they're trying to draw a distinction where they have a 500-page report and they're going to be the ones who decide if it's facts or data or whether it's opinion. I just don't think that's a distinction that's meaningful. It's not going to save time at trial. And there's really no question that all of their experts, we detailed the citations in our brief, relied extensively on this report. And then add to the fact that Mr. France will be here at trial to talk about the report in person and answer any questions that anyone has for him.
What else?
That's it, Your Honor.
What
Unless the
about
court.
residual hearsay?
Well, I certainly think that it does fit residual hearsay because it's this unique situation. It's reliable. All the plaintiffs' experts relied on it. Our experts relied on it. All the federal courts relied on it. It's now part of the dam safety industry. They do trainings on it. So this is a widely accepted document. And it is,
Do you have anyone who can testify to that effect?
yes, yes, that's in our expert report from Dr. Olson. And then Mr. France himself is a widely respected engineer in this field, and he'll be in court. So we don't see how they can draw this new distinction they're trying to draw. Their experts didn't just rely on facts or data. They also relied on the conclusions of this report, the opinions of it. Those are, again, we cite to all of that in our brief, Your Honor. This is not a close question.
How would you propose, in your mind's eye and in your co-counsel's mind's eye, how do you envision this becomes offered as an exhibit, and then you make your position on why it's admissible, the plaintiffs respond? I mean, what witness is it being offered through? Who, I mean, tell me what does the logistics of this look like to you?
Well, the report will be offered as an exhibit. The witness who can talk about it is John France, who is the leader of the IFT, of the independent forensic team, will be here to testify about it. All of the plaintiffs' experts relied on the report, so they'll have to explain how they relied on it. They already have, some of them in depositions. Our experts will also explain the basis for the report and how they relied on it, and the role it currently serves in the dam safety industry. So this is.
All right.
Thank you, Your Honor.
Anything else?
Not on that motion, Your Honor. Thank you.
Okay, thanks. Do you want to cede your 12 minutes to brother counsel for his rebuttal?
Was that a yes?
I'll give you a little more than maybe your minute and 15, since he didn't take nearly as much, but I don't want to, that's not going to happen in trial. So don't think that, if you go shorter, the other guys are going to get, no, in all seriousness, I'll give you a couple minutes.
Yeah.
Tell me.
Your Honor, as the party who's offering Mr. France and potentially other IFT witnesses and the IFT report as expert evidence, our opponents, the defendants, have the burden of qualifying him as an expert who's qualified in the field. I don't dispute his general qualifications. I don't know the man. But as to his sound methodologies, principles of engineering, and the methods that were used to come up with the conclusions that are in the hearsay report, we have no idea what they are. They've never disclosed them. So to the court, to the extent that the court says the plaintiffs could have done more to compel it, their burden in order to support this witness as offering an admissible, proper Rule 702 expert opinion testimony, they should go to FERC, use the 2E, use the CEII process, produce
You all named him as France, for example. His name is France, right?
John France.
He's on your witness list, right?
We're not calling him.
But
No.
that's not my question.
Yeah.
He's been on your expert witness list since the first expert witness list was provided. Is that correct?
He's not a retained expert for no.
Answer the question.
Your
I'm asking.
Honor, I don't know the answer to that question, frankly. I'm sorry. But if he's on there as a will call or may call, I don't know. We're not intending to call him, but.
I get that.
But our motion.
I'm not the brightest bulb on the Christmas tree, but I understand that one.
I might be the next dimmest, Your Honor.
No,
They're offering him, they clearly intend to offer him, right? The answer to that question
Sounds
is
like it.
yes.
Yes.
And as the party offering to propound him as an expert, they have the burden of disclosing to us the methodologies and principles and methods so that we can test reliability. We have not had any opportunity to test through cross-examination, disclosure to our experts, just discussing it amongst ourselves, whether the methods that were used to come to these conclusions are reliable or unreliable or something on the spectrum in between. And so we tried to depose him after he offered his affidavit, basically saying, I'll sign off on anything in IFT, and FERC stepped in to stop it. Now, could we have done more? Potentially.
We're going to go into number 3. Is
Yeah.
there anything else you want to talk about?
And as for Olson, the case law makes clear, the cases that we cite, including Fackelman, The testifying experts cannot look back to a non-testifying expert's report, which is hearsay, and become a conduit for the non-testifying experts' diagnoses, opinions, or conclusions. Those are independent and they have to
But
be,
do you agree that Michigan law, if you want your expert to testify, that which your expert relied on has to be in evidence?
yes,
Okay.
Yes.
I'm,
I do.
okay.
I agree with that.
All right, good.
Okay. Your Honor, moving on to the IFT witnesses.
Okay, hold on.
Yeah, sorry.
Number 2 is submitted. Thank you. All right, number 3 is plaintiff's motion in limine to exclude expert opinion testimony from non-retained independent forensic team members. I have, each one of these motions has their own binder today, so let me get to the next binder. Thank both my judicial assistant, Mrs. Tomet, who's kept me on the straight and narrow for over a decade. Her award in heaven will be great. And I thank Ms. Husa for helping me prepare, as well as the lawyers. I thought the submissions, like I said a minute ago, I had 30 cases on that we had on our panel. I sat one chair over, and a lot of substantial matters. And this is very substantial too. But the manner in which both sides, teams of lawyers presented their pleadings was helpful for me to get ready for this morning. So thank you. I appreciate it. Anyway, okay. All right, we're on to the third. Let me get the clock back up. Okay, please.
Your Honor, I think much of the substance of this argument overlaps with the argument previously. And so in a nutshell, the members of the IFT team were John France, Ifran Alvi, Arthur Miller, Jennifer Williams, and Steve Higginbotham.
France, Albee, Miller,
Williams.
and Higginbotham.
Higginbotham, correct. No expert reports were produced for any of those witnesses individually. They have not disclosed the specific topics of their testimony. They have not disclosed prior cases in which they've testified. They have not disclosed what the methodologies, principles, and methods were that led to their opinions. And as we've discussed previously, the federal government has stepped in to put a stop to them testifying about the process for developing the report and its opinions and conclusions. And so the primary challenge to these witnesses is that the principles and methods are unknown, and the defendant cannot meet its burden of showing that their opinion testimony is the product of sound and reliable principles and methods accepted in the scientific community, subject to testing or replication, or have them available here for cross-examination as to the merits and foundations of the science. There's no attribution or authorship identified because the IFT process was collaborative. I think there's going to be an issue if Mr. France comes to testify as to what FERC's counsel is going to do then to police the scope of his testimony, which is another reason at this point, we're 11 months past the expert disclosure deadline, and we haven't received any of that information. As to the factual bases, facts are facts, data is data. Those are fair game. And just by saying that, the defense doesn't get to use this report as a basis for hearsay opinion testimony doesn't mean that they don't get to use the facts and data. Both sides get equal access to the facts and data, which is undisputed in the IFT report. No one questions the reliability of the measurements, the lab results, the test facts and data in there. And so what we have no idea about is the deliberative process and methodology of how the members of the IFT team took the facts and data that everyone knows of, created a model, and then arrived at their hearsay opinions and conclusions. And without that fundamental foundational basis for expert testimony, it's not admissible. The residual exception to hearsay is reserved only for a narrow set of exceptional circumstances. The fact that this report was independent is not enough. It doesn't relieve any of these 5 team members from the,
Okay, so both sides are asking this court and the previous judicial officers who were assigned the responsibility of being the trial judges on this case. Each side is saying, Judge, we want you to decide, we need you to decide whether or not the catastrophic events of May 2020 can be accurately and fairly described as an inverse condemnation, such that the property owners who have a financial injury should be compensated. I don't have a time machine. You don't have a time machine. Mr. Gamble doesn't have a time machine. None of the other great lawyers in this case have a time machine. The court has available a report that has been attached to submissions in this court in their entirety since September 2024. So 14 months ago, it was presented in its entirety, and never has there been interposed an objection to, oh, you can't use it. The court has reviewed deposition transcripts of Mr. Sturdivant. I've listened to his testimony. That report is talked about at great length. Back to my time machine discussion. You have a group, this Mr. France, L.B. Miller, Williams, and Higginbottom. Then they're not all misters. These individuals do whatever it is that they do, and they generate this report. How is it that such a document, which has been proffered to the court so many times without any interposed objection or discussion or anything of that nature, how is it that there is anything else as comprehensive that could potentially assist the court in meeting its responsibilities? I know that your side has come up with Dr. Williams' model, and the defendants are seeking to exclude that.
Mhm.
Newsflash, I don't think they're going to be successful. Yeah, I'm sure they're very surprised at that. And when I look at that, okay, Dr. Williams wasn't there. Dr. Williams didn't, go on scene, didn't take the measurements. I'm just, why
Yep.
doesn't this fit into the residual hearsay because of the very unique facts and circumstances of that which you have asked the court to do, that I'm required by my duty to do?
Yeah, Your Honor, I'm not without sympathy or empathy for the situation that you're in when the plaintiffs come to you and say, we want you to get a really sharp pencil and go through IFT essentially and excise the portions that we think are admissible and probative, sufficiently reliable for the use of considering their weight in comparison to the weight of countervailing evidence on either side of the case, while also ignoring and excluding the conclusions. Because as the finder of fact in a bench trial, that's your responsibility, right? And so I was thinking about this a lot yesterday as I was preparing for the motion. In the hierarchy of things that plaintiff's counsel for the Mass side, Kevin Carlson, thinks should happen here, I think there's a basis under Fackelman to say that the conclusions and expert opinions, which are testimonial and deliberative and require the foundational requirements of 702 to be met, that the conclusions of that report should be excluded. I think that the uncontroverted facts.
Counsel, you haven't told me what those are. And it is Hornbook law in Michigan. A party cannot simply take a position, not provide adequate either factual or legal support, and then require the court to become the party's own legal assistant. I'm paraphrasing the appellate case law on this, but this does sound like a different position than that which was articulated in in the pleadings.
Yeah, you're,
I got the impression that you wanted it out.
no, in our reply brief, Your Honor, I think we go through and say facts and data should come in, opinions and conclusions should come out. And I think that we put in our brief a chart of the pieces that we identify as testimonial inadmissible hearsay. But what I'm getting at, Your Honor, is, you know, in the hierarchy of things that I want or I think ought to happen, and I'm self-serving, I'm advocating for my side here, and I'm also preserving a record. I don't think it gets in under the exceptionally narrow residual hearsay exception. I think Fackelman justifies separating out testimonial hearsay from witnesses who are either not being made available or who haven't otherwise complied with 702. I think the next best thing that could happen for everyone, including the court as the fact finder, honestly, is just let it in and consider it for its weight. And when they can't answer on the stand, what were your reliable principles and methods that led to these conclusions? That testimony, which we expect them to admit on the stand, should be considered in weighing the probative value of what they offer the IFT report for.
Well,
And if that's where you're leaning,
yeah,
Judge,
mean,
I
that's where I'm
understand
leaning.
why.
It's sort of like,
Yeah.
God, team, yeah, for both sides. Everybody deserves a closure to
Yeah,
this
I get that,
on,
Your
on the
Honor.
liability issue.
Yeah.
And if there's liability found, then we go to the next stage. But I'm
Yeah, I would just like to reserve,
All right.
I would just to make sure we reserve and do not waive our argument in case we need to make it for further review, that we don't think the opinions and conclusions which you've identified in the briefing ought to come in from IFT. The facts or data should. The next best thing that could happen for everyone involved as the collective royal we in this room would be for it to come in to be considered carefully for its weight.
all right.
Thank you, Your Honor.
Thank you. We have just, hold on a sec. Dan, do you have a stapler? May I have it, please?
Thank you.
When I was at in January 2003, when I went to new judges school, they had all these superbly experienced and qualified judges teach us at in Lansing. And they said, when you're in court on the record, when you're not talking and when nobody else is talking, it seems like an eternity, but it's really not that long. So take your time, write your notes. If you have to, calm down and take a recess. So I try to remember those things, but I needed to take a few notes based on Mr. Carlson's thoughtful comments, and not that everyone else's, Ms. Rhodes, Mr. Cools, Mr. Gamble's were also very thoughtful. I just had, we're on the third motion. I'm trying to keep things straight. So Thank you. All right, continuing to the response to motion number 3 is Mr. Gamble. You may proceed.
Thank you, Your Honor. We don't have much to add to what we've already said. There is one correction I really want to emphasize and make sure is clear on the record, which is that the plaintiffs continue to say that the federal government kept them from deposing any of these people, and that is not correct. They said
Okay.
yes.
Yep, I've read your positions. I understand that.
Okay.
I do have a question though for the defense. One of the other things that the plaintiffs talk about is your side didn't do that which is necessary to have Mr. France or anyone else, whoever else. Let's just the 5 individuals who are the ascribed to be the authors of this report. I was gonna say the 4 Lakes Task Force report. I'm confusing my acronyms and reports. The Independent Forensic Report. They say, as I understand it, you all have not done that which is the condition proceeding under the rules of evidence or the court rules or the court's orders, I think, to have them testify. Do you understand that position?
I understand their position.
What is your, do you have a response to that position?
Yes.
I would be interested in hearing it.
Our response is that there is no court order that required a report be prepared by non-retained experts. We haven't retained Mr. France. He's been on the plaintiff's witness list for the entire duration of this case. They could have contacted and spoke with him at any time. They could have deposed him and they decided not to. So he's not a retained expert. The court's case management order only requires retained experts who are going to be presenting as testimony as retained experts prepare a report. And those of our retained experts who will be testifying have prepared reports, and so have the plaintiffs. And one other point I do wish to emphasize, if that answers the court's question, before I go to the next point, I didn't want to cut off that line of.
Does the 700 series of rules of evidence require it?
The preparation of a report?
Yes.
No.
Okay.
And in response to discovery requests, the defendants have provided the plaintiffs with everything that they have about the IFT report and its group, its communications with the IFT, any of the information the IFT gave to the defendants. So we have the same amount of information here. It's just that the plaintiffs decided not to depose Mr. France. They could have.
Have you deposed him?
No.
Did you depose him in any?
No.
You've had your name on a lot of captions. Did you depose him in other cases?
No, Your Honor. No.
This will be a first for me in 40 years. If Mr. France testifies, to have someone who is an expert who has not been deposed. I don't think in 40 years I've ever seen it. I'm not saying I'm just, that's a colloquial observation. Court of Appeals, please, when we're doing this, I'm not being critical. I'm just making an observation. Okay. Go ahead.
Really, my final point is just to kind of foreshadow this trial, which is that the plaintiffs have raised the fact that the IFT report was prepared by not just Mr. France, but by others. And they've said that that's a basis to exclude the report. And the reason I'm emphasizing this is that the defendants already raised a similar issue and lost, which is that we argued that Mr. Sturdivant's report, which he did not write, this is not controversial, he acknowledged this under oath, he didn't write it. It was written by a group of attorneys who we don't even know who they are. So
Right, but I mean,
I understand, but the fact that Mr. Sturdivant adopted that and said, yes, I agree with these, that was enough for the court. And so my point is just that how can the plaintiffs now say that Mr. France can't appear and say, here are the
Line of
conclusions.
the expression, sauce for the goose, sauce for the gander. Yeah.
Exactly. So with that, Your Honor, we have no further comments. Thank you.
Thank you.
Nothing else, Your Honor. Thank you.
All right. I'm ready to keep going, but I'm happy to take a short, recess if folks would like. We good to keep going? All right. Thank you. Let me just staple, trying to keep these in some semblance of order. Don't start yet. There, young man, but give me a second. Catch up with you. I gotta put today's date on these, otherwise. Counsel, how do you pronounce your last name?
Frischkorn, Your Honor.
All right, Mr. Frischkorn, thank you. Have you been before the court in this matter?
I have not, Your Honor.
Well, welcome. You join this happy band and of outstanding lawyers that I have the privilege of serving and your clients. And so welcome. How long have you been with the AGs?
About a month and a half.
Old timer. Okay, great. All right. So we know, all right, good. Well, Mr. Fishkorn, welcome. It's a fine office, just as all the plaintiffs' lawyers firms are. Man, we've got this is a superstar list of law firms and lawyers. So thank you. Glad you're with us. Please proceed.
All right, thank you, Your Honor. I'm here to argue defendant's motion in limine to preclude testimony of governmental inaction. I want to start with this court's October 1 order denying defendant's motion for summary disposition, which noted that plaintiffs must demonstrate that Eagle took actions above and beyond an alleged malfeasance or did more than simply fail to act. And that's really the basis of what brings us here today on this motion.
Right. Yeah. May I make an observation?
Yes, Your Honor.
Years ago, I had the privilege of serving and then being chair of the Model Civil Jury Instructions Committee for our state Supreme Court. And it was really opportunity to be with just superstars. The Model Civil Jury Instruction Committee, as well, civil jury instructions, and in the Model Criminal Jury Instructions. When charging a jury, a trial court will typically say words to this effect. You may base your decision only on the evidence which was admitted into court. The lawyer's arguments, questions, or the court's statements or instructions are not evidence. Evidence is the material that was introduced as exhibits in the trial or the testimony of witnesses. And then the court later on in both civil and criminal cases will say there are two kinds of evidence, direct and circumstantial. Direct evidence is evidence which directly speaks to a specific thing, and the observation of it is evidence that a thing happened. Circumstantial evidence, on the other hand, is evidence which one can look at and can reasonably infer from it a set of facts based on the circumstance they observe. For example, if a person walks in from the outside and is wearing a raincoat and it's covered with water, that is circumstantial evidence that it's raining outside. Circumstantial evidence or direct evidence, either alone or together, can be used to prove the burden of proof that the moving party has to meet. Okay? So every jury that ever hears it has to make a decision. Here's those, some variation of those instructions. That which the government seeks in this motion, it appears to me you're seeking to exclude what arguably could be discussed or considered as circumstantial evidence. And how, if that is that so or not? If it is so, how would that be appropriate for me to grant that relief?
Your Honor, our position would be that this isn't circumstantial evidence. The black letter law in Michigan is that inverse condemnation claims or taking claims in general require affirmative acts by
Right.
government actors.
Right, but how I said moments ago that I don't have a time machine and none of the lawyers do. nor do any of us have a magical, device that we can drop on the head of a witness to say, to tell, oh, he's not being 100% candid. He's keeping 80, he's telling us, or she's telling us 80% of what's correct, but 20% they're not sharing with us. We don't have that. It's an imperfect system. We're imperfect humans and we have to make our decisions. And how can, if there is some failure of action and of whatever nature, and then subsequently there is an affirmative action, why shouldn't the plaintiffs be able to say, Judge, we're not saying this meets our burden that they took an affirmative act, but you can consider this other stuff in deciding whether or not it's an intentional act.
Your Honor, I think it helps to use an example that we used in our
Great
brief.
with example. I have three kids. I'm great with examples. They're all adults now and I have two grandchildren. They're not quite old enough for examples yet, but they, go ahead.
All right, so we'll go to Mr. Sturdivant's testimony. He criticizes two things.
And I haven't done this yet today, so you're gonna think I'm doing it just because it's you. But the lawyers all know I have some back issues, so I'm gonna stand and stretch a little bit, but please continue.
As someone with back issues, I understand myself, so. Mr. Sturdivant has criticized the state's decision to grant a permit authorizing the raising of the lake level in spring of 2020.
Yes.
He has also criticized the fact that the state did not order the lake level to be lowered, such as taken down to run of the river, right? The granting of a permit could be considered an affirmative act. That's fair game. That's not something we're asking to exclude here. However, the fact that the state did not order the lake level to be lowered can't give rise to a takings claim under the case law in Michigan, because that's an inaction. It's something the state didn't do. So it cannot give rise to takings liability. It's more appropriate as it's more akin to a negligence claim based on a failure to act. That's the distinction we're trying to make here.
Right.
And if the court has any more questions about our argument, I'd be happy to answer those. Otherwise, I'd like to turn to rebut some of the points in plaintiff's response brief. So our position is that the plaintiffs somewhat misconstrue the Court of Appeals opinion in this case. They state in their brief.
You read a lot. A lot of the opinions that are a matter of record, both sides, that they're advocating on behalf of the clients, and that's outstanding.
So what I would like to start with is the proposition in their brief that there's no exact formula to establish an inverse condemnation claim. What I would like to do is read the whole quote, which I believe supports defendants' positions, not plaintiffs. Quote, while there is no exact formula to establish a de facto taking, there must be some action by the government specifically directed toward the plaintiff's property that has the effect of limiting the use of the property. So that's the exact quote. There is no exact formula, but even there, the court says there must be action. No court in Michigan has ever found inaction to be sufficient for a takings claim. The plaintiff's brief, they also say that the state's decision to, or the state's failure to disclose dangers is relevant to misuse of authority, but the Court of Appeals never said that. The Court of Appeals talked about active efforts to conceal. There's a difference between the state taking action to conceal something and the state inactively not disclosing something. We think the latter should be precluded, while the former would be fair game. Another point that I would like to.
Why is it different than your principal argument? If the state intentionally withholds information, but they don't act How is that different?
Our position would be that that cannot give rise to a takings claim because that's inaction. There's a difference between actively trying to suppress information and just simply not taking action on the information. And we're not conceding
You're not
any of that.
I know you're not conceding that it happened, but
Another point I would like to turn to in plaintiff's brief is they suggest that if the defendants made a deliberate choice to not do something, the decision-making process can be considered an affirmative act. A case that was not cited in our brief, and it's not a takings case, Johnson versus Pastoriza, Pastoriza, that's 491 Mitch 417, 2012. It's a Supreme Court case involving,
491 Mish
what was that?
was the 491 Mish what?
417. And it's from 2012.
Okay, go ahead.
So that case involved the claim for medical malpractice and wrongful death of a fetus. In that case, a doctor refused to perform a procedure. And the dissent of the Supreme Court argued that the active decision-making process, the decision to not do something, made it an affirmative act. And Justice Sara, writing for the majority, said that what that would do is, quote, morph all willful omissions into commissions. That court says, rejecting the same line of reasoning that plaintiffs are bringing here, is that a refusal to act is to abstain from action and cannot be considered an affirmative act. It's not a take.
Let me ask you a question. And I know we're going a little over time on this. If Mr. Frischkorn, it could be established. If it could be established that agents of the two state entities who are defendants believed that the dam would fail. Absolutely believed it was going to fail. If you got a rain like happened around May 19th, 2020 and did nothing. Is that an adverse taking?
No, Your Honor. It is our position that the black letter law in Michigan, every single appellate court that has addressed this has said inaction cannot support a takings claim. So the hypothetical that you just presented, if it was that and nothing more, that would not be sufficient for an inverse condemnation claim. Inverse condemnation is appropriate where the government, for example, if they build a highway across your yard and they're supposed to condemn your property, go through those proceedings and pay just compensation. But if they don't do that, that's when a takings claim arises, which is not the situation that we have here. Failure to act has never been found by an appellate court in Michigan to give rise to inverse condemnation.
Okay, my time says you're like 18 minutes. Is that what yours says?
I have 12.
Okay, well, you got a few minutes for rebuttal then. I'm going to assume that the kid who's 35 years younger than I am is probably able to operate an iPhone better than I can. So, all right. Okay, do you want to finish or do you want to just save for rebuttal?
I would like to finish, Your Honor, if that's acceptable.
Okay,
Um,
now I am going to try to run the clock correctly. Okay, go ahead.
So just to wrap up, plaintiffs cite absolutely no authority holding that inaction can give rise to a takings claim because there is no authority in Michigan that holds such. Every court that has addressed it has said that inaction cannot give rise to a takings claim.
I don't disagree that inaction cannot give rise to a takings claim, but I think it is interesting to thinking about it. Can a whole bunch of inaction inform what the intent is of an actual action? And I think that it should. I mean, it just if, again, this is the first time you had to suffer through me in a hearing, but the lawyers have heard about my kids for a couple of years now. And I mean, if one of my children, they're all amazing people, I think, and I'm so blessed to have them. But if there's a bunch of things where I've asked all three of my kids together, your mom and I need you to do A, B, C, D. Okay. I go to work, I come home, it's middle of summer, A, B, C, D. I mean, there hasn't been so much as a shovel moved, let alone a rake or a lawnmower. Okay. Like that night at dinner, I say, hey guys, I really would appreciate it if you need to close the deal on this. We're going out of town. Mom and I need you to do A, B, C, D, and E. Oh, okay. Yeah. Right. Dad. Good to go. Fine. Come home the next day, nothing. And then, I find out, I ask them to do something else. And then they do something completely different from what I asked. Can't I, as a dad, consider that I asked A, B, C, and D twice? They told me they were going to do it and then they didn't. Not that this ever happened in my children's life. They were always perfect, of course. But if it did, wouldn't I reasonably be able to look at this third thing that they did and they say, oh no, I didn't do that. It's like, well, wait a minute. I told you to do this stuff. And you said, can't I logically consider it? And if in fact I can, then why, getting back to what we started talking about as far as circumstantial evidence, the rain on the rain, the drops of water in the raincoat, why can't I, as a trier of fact, consider inaction, if there is any evidence of it, in trying to evaluate the currency of the evidence proffered by the plaintiffs?
Because it is insufficient to meet their burden under the constitutional takings clause.
It is insufficient. I agree with that. But is it under 401? Does it have some relevance to establish a fact of consequence? Is there some value to it? And I guess as a father, I did find some value in the wonderful interchanges I've had with my children from the time they were 0 to the time now 38 and younger. It informs every relationship. I mean, I think of when I have been in the Navy and when I had command, and I never prejudged anybody, but how a specific senior enlisted person or an officer who I had the responsibility of being the CO of may have undertaken certain tasks, it would help inform going forward. I find the argument this logically counterintuitive.
I guess to answer the initial question, our position is no, it's not of consequence in determining the action. Because there's a difference between, for example, torts, which can be based on inaction, and a constitutional claim under the takings clause. And that's really where we're making
I
that
agree
distinction.
completely. I absolutely agree completely. If all you got is a 50 non-actions, you're never going to get there in a constitutional thing. Okay. I appreciate it. Welcome.
All right, thank you, Your Honor.
Congratulations on your position. Are you a new lawyer too?
No, I was sworn in 2021.
Oh, okay.
So-
Old timer. All right, good.
All right, thank you, Your Honor.
Anybody on that side of the V have anything different they want to share? I was sorry to hear about your one colleague who sent the email or something. I won't say the specifics of it, but they under the weather on something that's unpleasant. So anyway,
It's the world we live in now.
it is that.
Good morning, Your
I
Honor.
hope that lawyer's feeling better.
I'll pass that on. Good morning, Your Honor. Jason Thompson, for the class. I'll be arguing in response to the motion on inaction. And there's really two fights going on here. One is that the defendants are seeking to collapse 401 relevancy down to affirmative acts. And of course, that would be an improper application of 401. The second argument really boils down to one word, and that's context. Every Court of Appeals decision dealing with inverse condemnation emphasizes that the court or the trier of fact has to look at the context in which all of the actions took place. It would be an inglorious ending to this case indeed if the plaintiffs came in January 12th and put on a negligence case. We understand what affirmative actions are.
Pretty short case.
It would be quite a short case. That's not going to happen. No news flash there. We understand what the obligations are. And an affirmative act, as the Court of Appeals has said on page 4, 5, and 7 in our brief, is fact specific. We're going to have to get into that stuff. And you just can't collapse relevancy down to what they are calling affirmative acts. So we would ask you to deny the motion.
Okay. Thanks. We ran the clock out, Mr. Frischkorn, but I let the other side grab some of your clock when Mr. Gamble didn't take us long. Do you have anything you want to share with us?
No, Your Honor, nothing bad.
Okay, thanks very much, both counsel. All right, that brings us to our fifth and final motion. My preference candidly would be to push on, get that one was, argued, and then take maybe a 15 minute recess. I'll be able to talk to Ms. Husa, who's been here with us, and then one of the other attorneys for the court, Ms. Stokowski, I'm guessing has probably been watching, so get her on the line, see if there's other areas they want me to inquire about before we sort of reconvene to talk sort of plenary session about, where things are at and how we're going. That sound okay to everybody?
Yeah.
All right. Ms. Omerod, you all right? Yeah. Do we need some more water or anything, or? I feel awful for you with that. That can be so uncomfortable. Okay. All right. Well, you heard my earlier observation, so.
I did, and I will not ignore those. I will be very brief. For the record, Richard Cole for the state defendants. All the motions that we've brought today, as I said before, are intended to narrow the issues for trial so that we can speed this process along. And this is one of those issues. In this case, Dr. Williams has testified the actions he took, the model that he used, were intended to recreate the conditions of May 2020. That's his testimony. And so the Supreme Court has held when you are trying to recreate the conditions, for it to be relevant, for that evidence to be relevant, you have to show a virtual identity of conditions. And the problem that we have here is that Dr. Williams has admitted that his inputs into that model were incorrect. He's admitted that we know what the size of the spillways were, and yet he decided to use information showing that the spillways were 19 feet longer than they actually were, which would allow more water to exit the lake, thereby artificially lowering, using the model, the levels of the lake, which is what their goal is.
How does, again, it's sort of the weight admissibility. That sounds like a very thoughtful cross-examination questions, but why shouldn't the party be able to share this information with the court? You expertly cross-examine it and demonstrate why it's not worthy of belief. They seek to rehabilitate on redirect, and then I weigh and measure it. I mean,
Absolutely, yes. Those would be prime topics for cross-examination. I think the only difference here is that the Supreme Court has said, unless there's virtual identity, we're not even going to get there. Again, we're trying to limit what's going to happen during a trial. And we've identified 3 significant areas that Dr. Williams has admitted that he did not input into his model. And therefore, because they cannot show virtual identity, we think that the court should preclude any reliance on that. Again, it goes to that model. It's not demonstrative evidence. It's not meant to illustrate it. It's a model they use to calculate the height. That is not demonstrative.
in their response to your motion, the plaintiffs appear to describe what they're trying to do with this differently than that which you seek to exclude in your motion. What's your response to that?
As I understood their motion, they were saying that the model that he used is used in other situations, similar situations. That's fine. I'm not arguing that.
Okay.
Our argument is he knowingly inputted into that model false information. It's when you do that, when you take that step, that there should be preclusion.
Okay.
Thank you. I appreciate your time.
No, appreciate yours, as always. Lucky to have the lawyers I've got on this case. I know that. I may not always act like it, but I do appreciate it. I do know it. It's, I try to be prepared for hearings. And boy, I couldn't ask for lawyers to try to be more prepared. You over prepare me. So, all right. Enough of the.
You haven't heard my argument yet. I don't want to,
Yep. So, all right. So you've heard, Mr. Cool's argument. My question is, all right, A, did the proffered witness input measurements? So size, so something that we can all probably agree on. I mean, we all agree a royal foot has 12 inches, you know, and a meter has 100 centimeters and an inch has 2.54 centimeters. I mean, were the numbers inputted into whatever, you know, Nimbus 2000 formula that's
Yep.
used, were they correct?
No, my understanding is that this is a misleading assertion. The HEC HMS model that Dr. Williams used does not call for geometrical measurements to be inputted into the model. And there's several reasons for that. One is because you're trying to model what the behavior or elevation of water was in a reservoir based on a dam, a geometric structure that no longer exists. It got destroyed.
Right.
And so you can't.
No, I get that.
Yeah.
But there are loads of historical representations of what it looked like. And while you may
Right.
not be able to make it so it's an exact replica that would meet, you know, that's a clone of it, for
Right.
example, you can, I'm assuming somebody has the original engineering documents or somebody has, here's how high it is, here's how wide it is, here's when it was put in. I mean, I have some, and I'm not trying to be flippant. I mean, I
Yeah.
have a recollection of
No.
you all describing these
No,
things.
no,
in the
Your
last
Honor,
couple of
and
years.
I'm trying to balance somewhere between answering your question, understanding that I'm not a hydraulic engineer, right? I'm
Right.
doing.
What I
so-
but what I don't get is why, if you know that the spillway size has been talked about at great length.
Right.
Why would you not put in?
Yeah, here's my understanding as to why, in a nutshell, okay? When hydrologists like Dr. Williams model spillway discharge, he's looking for inflow, discharge, changes in the elevation of water over a period of time. They don't use the structural width of the concrete opening, the portion of the spillway that actually conveys a discharge of water from that section of the structure. What they use is ratings curves and other data points related to the water. And so what Dr. Williams explained or attempted to explain to opposing counsel during his deposition was that whatever the spillway is in its measurement, it is, but the input of that raw geometric math doesn't get inputted into his model. It's baked in to whatever the inflow, discharge, and elevation numbers are. And that's the standard practice in the field. It's the same approach used by federal agencies, by the Army Corps of Engineers, by the Federal Energy Regulatory Commission. The raw architectural data, which tells you how wide the concrete structure is different from what they call the effective hydraulic width, which tells you how much water the spillway actually passes and how much water the reservoir actually holds. Hydraulic models require the latter,
Effective hydraulic
effective hydraulic width,
width.
not the raw architectural width. And so the most they can say, and by the way, they haven't brought a Daubert challenge to Dr. Williams' report or his testimony. They haven't said that his engineering process is flawed or inadequate in any way. The most they can say about him is that his report has imperfections because he should have inputted raw geometric mathematical data, and he's going to say apples to oranges. We use effective hydraulic width. We don't use raw geometric data in this type of analysis. So that goes to the weight of his testimony. And there's a case that I want to draw the court's attention to that I don't believe is in our brief. People versus Lemons, Lemons, 514 Mich 485, a 2024 Michigan Supreme Court decision, very sad, disturbing set of facts regarding a shaken baby syndrome case, okay? And there's an expert who, for obvious reasons, biomechanical expert can't recreate a case of shaken baby syndrome. An expert in that case has to use a model. And so the party opposing the admission of the defendant's expert said, well, this model, there's a gap. There's not virtual identity between the inputs into your model and the victim of this alleged crime. And what the Michigan Supreme Court said is that there's not a requirement for perfect replication or virtual identity when an expert uses modeling testimony.
Right, but obviously, no one in a civilized society, and hopefully no society anywhere, would ever allow a doctor to shake a child until its brain is injured so much that it'll be a inconsistent with life injury.
Right.
Of course. Your situation is you have a hydrologist, I think, who has a computer model.
Right.
So we're not asking him to go find another dam and to blow up the Croton Hardy Dam.
Right.
We're not asking him to go to Foot Dam at the tailwaters of the Ausable River before you get to Lake Huron and say, to do this, to be admissible, you have to blow up a dam. Nobody's saying that. He's doing a computer thing.
Right.
And what it sounds like from the defense, he inputted information which is physically not accurate.
Right.
How does Lemons speak to that?
Because Lemons says, quote, neither the scientific method nor MRE 702 require that sort of perfection. Quote, in the realm of biomechanical evidence, there can never be a perfectly replicated model. There will always be at least some gap between the data and the conclusions reached. This cannot and does not prohibit a qualified expert from testifying on the basis of reliable principles and methodologies about what can be extrapolated from various imperfect modeling. Dr.
Right. No, I
Dr.
mean,
Williams,
Lemons,
yeah.
If there's a judge on the Michigan Court of Appeals who is not very familiar with Lemons and the whole body of case law leading up to expert witness testimony about child victims, child sexual assault, opinion testimony, I've never met that judge. So I get Lemons. I've read it multiple times. It's not, we are not talking about a biomechanical. We are talking about a earthen dam, which gave way. The people with a whole lot more capable scientific analysis capacity than I have come up with these computer models. And I just don't understand why, if, it's not going to hurt anybody or anything if you're running it with the correct numbers that, or I just don't understand.
What Dr. Williams would say is that when you're trying to measure inflow and discharge, inflow and outflow, putting in the raw geometric architectural measurements, even if you did know them, even if you did still know exactly what they were, given states of deterioration, damage, accounting for what damage was caused by the liquefaction and the destruction of the structure, even if you could go perfectly do it again, that wouldn't be what hydrologists do in part, and it has to do with the way that they calibrate the model, right? the testing curve calculations are not driven by those exact architectural measurements. It's just not how it works. And he'll say it's apples to oranges and he'll give an explanation. It's not as if, we're trying to, we have a car crash involving a Ford Bronco, and we're going to have an expert say, well, I took a Ford Bronco purchased from the same dealership, same model year, and I ran it into a wall at 80 miles an hour to replicate the crash. And here, Your Honor, you can see exactly what happened because I put 4 dummies in the approximate weight of the plaintiffs, and this recreation evidence should decide the case. This is more like a Lemons type test where we're modeling something that we weren't present to see with our own eyes and ears, so that a hydrologic expert can say, based on the model, here are the conclusions I draw from the appropriate data and modeling. And so he'll defend it all and explain the weight of his testimony on the stand.
Thank you.
Thank you.
Mr. Cool?
Very, very brief, Your Honor. I hadn't cited the Lemons case, so I had not reviewed it, but it seems to me the Lemons case was based, as it was described, was based upon a lack of information. That's not the situation we have here. We have the information. It's just that Dr. Williams decided to ignore it and not use it.
To your knowledge, did the witness, is there a place I just bought some Thule roof racks for a car my wife and I just got. And I have to tell the vendor, here's what I got. So I'm required to put in information, either orally if I'm doing it through a salesperson or digitally if I'm doing it online. Did this model that the proffered witness used, to your knowledge, did this witness have to enter in a number about it's 60 feet long, it's 80 feet long, it's 100 feet long?
We know as to 2 of the issues, we raised 3 issues. As to 2 of them, we know he did, and he input incorrect information. That's the length of the spillway, and the other issue was the 3rd issue that we raised, which was, the height of the gates.
Right.
We know that there were inputs for that, and he put in the incorrect information. They talked about how the model doesn't rely on architectural figures. Well, then how is it relevant? How is it more likely than not to show exactly what happened? It seems like their argument was self-defeating and an admission they can't show virtual identity.
What, do you know, and I apologize, I just don't know, when was this modeling done?
For purposes of this case, it was done relatively recently.
Okay. All right.
Thank you, Your Honor. Appreciate your
Thank you
time.
both. Thank you all. All right, so it's 10:25. What I'd like to do is take a recess until 10:40, so 20 minutes before the hour. That'll give me a chance to, as we used to say in the Navy Marine Corps, take a health and comfort break, which means what one would anticipate, and as well as counsel, and grab a small snack for myself, and then talk with the lawyers. What I want to talk about when we get back is I want to try to answer any questions council have as far as trial and what to expect. It's not going to be a talk show host thing, but we'll start with the plaintiffs. I'd also like to know sort of the attorneys helped me on the case, advised me that witness lists have been served. I think that's correct. I'm going to want to know do I have a copy of those yet? Have they been filed with the court? And one of the things I'm going to ask you to do is think about, for both sides, for when you take your witness list, I'm going to sometime and I'm not going to need this till our January 5th conference. I think that's the day of the next status conference. I'm going to want a ballpark estimate of how long you think your direct will be on a witness you're calling. I'm not asking you to speculate on how long you think the other side's cross is going to be, but I'm just trying to start thinking in terms of how long will we have the opportunity to be together? And, so, eh, anyway, thinking about that. So those are some of the things I'm thinking about that I would like to talk about when we reconvene at 10:20 or 10:40. And happy to listen to anything else. Does anybody have anything we need to talk about before we recess briefly?
Your Honor, may we use the conference room back there again?
Of course. Yeah,
Thank you.
yeah. You can use it together or separately, however you want to do it. Court's in recess till 10:40. Thank you. Let's go about your business. Okay. The time is 10:43. We're back on the record in the matter of Krieger versus two state departments. Apologize for a little longer break than I said we would take. I want to go back to the first motion. I don't want to hear everything you said previously, but I do have a couple of questions. I'm really sorry, Ms. Holman Road, and I'm sorry, Mr. Cool. But Mr. Cool, you were the moving party, so if you could just approach first, that'd be great.
All right, yes, sir.
Okay. What? Describe for me how you would envision if the court granted your order, what would that mean?
The circuit court entered an order that made various
Or not granted your order. If the court granted your motion as relates to this order, how does that play out at trial?
It simply means, again, we're limiting evidence that can be offered to hasten things along. And so they cannot offer any evidence that is contrary to the findings made by the court on, was it May 28, 2019? That's as quick, direct as I can state it.
So does that mean it would be the defendant's position that no evidence about the FERC revocation, no evidence about the actions of the state officers after the FERC revocation between when that took place and the 307 ruling?
No, all facts relating to those, I don't see why those would necessarily be objectionable or excluded. It's solely the issue of the setting of the normal lake level, did it for summer and winter. And really the focus of our argument is that they contended that that was not a safe level. Now they contend that was not a safe level. At the time, they were saying that was the safe level, and that's what led to the court's order.
So of the of the evidence that you're aware of, whether it's testimonial or exhibit based, can you give me an example of what you think would not be appropriate if the court granted the relief you seek in this motion?
Absolutely. They came in and argued from the moment FERC revocated its license that the state should have known that using the normal lake level was unsafe. That is the fundamental argument being made. Yet at the same time, they were getting ready and went into a court making the argument that it was the summer level was a safe level. Those are directly contradictory.
Okay,
Okay?
hold on just a minute. Okay, thank you.
All right, thank you, Your Honor.
All right. Solomon Road, would you like to be heard? So heard Mr. Cool's response to the court's questions. Assuming they are unsuccessful, okay, in their motion and it's denied, what do you see it in terms of witnesses, evidence, proofs that you and your colleagues would be offering on behalf of the assembled plaintiffs?
In terms of the lake level at that time.
Yeah, if you are successful in your defense of this motion, what are you seeking that would otherwise be proscribed by this? If the defense were successful, what stays out? If you're successful, what gets to come in?
Part of the problem for us in analyzing it is the meaning of evidence contrary is sort of imprecise, but as we see it, the evidence that we would be looking to bring in involves the issue of concealment. It also involves that they want to, no matter what the ruling is, argue that that's at the lake level and that means it's safe. And we're going to present evidence to the contrary of that.
Who through whom?
It would be through our experts such as Sturdivant. And potentially concessions through adverse testimony.
Right, right. Okay, let me have just a moment, write some notes. If you can stay there, excuse me for just a moment. I want to talk to Ms. Husa. Ms. Husa, could you come up here? Feel like I'm an NFL coach on the side. I don't want the other side. Seem like okay. All right. Well, that was a quick side huddle. So, okay. I don't have any other questions.
Your Honor, I have that citation that I mentioned previously.
Oh, thanks.
It is Prenducci versus Farmers Exchanged. It's 2015 Westlaw 5440200. Michigan Appeals, September 15, 2015. I've written it down if I'm saying it too fast or
No, you're
unclearly
great.
with my
What's
broken
the,
voice.
do you have a Court of Appeals case number?
I do not.
Okay. Thank you.
Thank you.
All right. Thank you all. Appreciate that additional insights. I will allow, being a kid who grew up in Detroit, I did take happiness in seeing the defensive coordinator for the Lions in last night's game against the Dallas Cowboys. He's holding up his thing and it's got 313 across it, which is of course the area code for Detroit. I thought, oh yeah, that's great. So I'll have to get some 313 ones made up for the trial. All right. Thank you for letting me go back and talk about those issues. Okay, so I'd like to now sort of open the floor for what the lawyers would like to talk about. And I don't have an agenda other than just the brief thing I talked about. So plaintiffs have the burden of proof. So as always, they get to go first.
Do you want?
You can stay there. And let me just ask our court reporter, ma'am, can you hear counsel when they're at council table if they
Closer.
hold the microphone?
Yes, I can.
Thank you. Okay, so you can stay at council table.
This is just for the exhibit list, and it's just a more of a logistical thing. Some of the experts have utilized data that's like data information sets, such as GIS data, and printing that off would make hundreds of pages. And we had proposed to Defense Council that we would do those on a USB, and we'll identify within the exhibit list that that exists. But then that'll be a separate, and even separate from the USB we're making of all the exhibits, because otherwise your clerk using the electronic would be buried in all of those documents.
We have no objection, Your Honor. I mean, what Ms. Almonroe is describing is essentially hundreds of sheets of just
Right.
numbers. And I don't think there's any reason to print that out.
Thank you. I agree. That sounds like an excellent idea, Ms. Almonroe. Consider the case scheduling order orally modified. I'm adopting that as my order. So as part of it, I'm not going to issue, if we have other things, maybe I'll issue another amended one, but for purposes of, that's fine with me. So.
Depending on the court's ruling in part to ruling on some of the motions today, and we may have some custodial records keepers provide records, probably most likely through deposition. We did not list, we did identify potential custodians on our witness list that we submitted to Defense Council, but we did not list those exhibits because obviously some of them we might have copies of, but we don't have originals, or we may not have those records yet. Is the court expecting, what is the court expecting us to do with those subpoenaed exhibits in terms of the exhibit list and the production to the court?
What's the volume we're talking about?
It's not going to be very large.
Okay. 1,000 pages, 100 pages.
I think less than 1,000, maybe a little more than 100.
I'm not sure what Ms. Almonroe is speaking about. This doesn't ring a bell. So I'm not quite sure what the request is here. So maybe.
Yeah,
if she can-
what are you looking
Well,
for from
Are
me?
there specific documents that,
Well, the
talking
documents
about?
that they're produced through a custodial subpoena,
Mhm.
Right now they're not on our exhibit list. But
I
the
assume you
witness,
have copies of them, right? Or do you not even have
some of
copies?
them we do have copies
Okay.
of, and to the extent we had copies from third parties, they're on our witness, on our exhibit list.
Yes.
To the extent, there may be a few that we didn't have copies of, and to
Mhm.
the extent that we don't, they're not in our exhibits. But also, to the extent that we may not have to do this, but if we have to subpoena some of the originals of some of those third parties, does the court want us to copy them again and put them in the binders and create more binders? I mean,
Your Honor, this in large part relates to the IFT motion.
Mhm.
And if theoretically the motion would result in us having to go find all the independent sources for the soils, the water levels and all of that, that's what we're referring to. So depending on the ruling, this could be a completely moot point. On the
I
other
think
hand,
you should plan for purposes that the IFT report is going to be considered by the fact finder. In fact, let me just, this is not my ruling, but for planning purposes, I think it would be, if I were trying to prepare for trial, I would expect that the first motion that was heard is likely, but which is defendant's motion, eliminate a bar evidence of the May 20th, 2019 ruling of the circuit court. It is highly likely that motion will be denied. The second motion that was heard, it is highly likely that the plaintiff's motion to exclude the independent forensic team report will be denied. It is highly likely that the plaintiff's motion eliminate to exclude the expert opinion testimony for non-retained independent forensic team members will be denied. It is highly likely that the defendant's motion eliminate to preclude testimony of governmental inaction will be denied. It is highly likely that the defendant's motion eliminate to preclude testimony based on Dr. David Williams' model will be denied. This is not the court's order. It is not the court's ruling. I'm doing this as a courtesy to the lawyers I know who are going to have to work very hard to get ready for trial. And if I alter, if the final opinion and order on these 5 issues is different from that which I am indicating today, the court, of course, speaks through its orders. So I don't anticipate that's going to happen, but if it does, it is the order that hopefully will be issued sometime next week, which will govern how we proceed. With that information, where does that put you?
But we might have a few documents, but not very many, that would be additional documents in such a subpoena.
Okay. Nobody can create that which they don't have. So I don't know, Mr. Gamble, what are your thoughts?
Well, right now under the court's pretrial orders, including its most recent order, the plaintiffs were supposed to provide defendants with their final exhibits by November 19th. That didn't happen. They gave us over 800 documents, and then just 2 days ago gave us a new list that removed half of those. So now it's down to about 400. And now it sounds like they're still contemplating additional exhibits that we haven't even seen, and I'm not sure what they're referring to. And so that is a concern for us in terms of trying to plan for, get the court the binders it needs next week. I really don't.
I'm sorry, I didn't catch what you just said.
The court has ordered that all the parties provide it with binders of printed exhibits next Friday. So I really think it's past the point where the plaintiffs should be able to continue to prepare an exhibit list that was due November 19th. We just got a new version of it 2 days ago. And now we're hearing for the first time that there's even
Right,
more.
but if they
exhibits
hadn't
than-
given you the one they gave you 2 days ago, you'd have had twice as many documents. So
Fair enough, but it affects our exhibit
I
list. And
get
so-
it. I get it. Believe me, that's why I've been trying to manage this in the best way I know how. And that's predictability, consistency. But I also recognize, and I mean, we've got this fine young lawyer who's just joined your team, but we've got 2 very experienced litigators in addition to our newest lawyer on the team. On the defendant side, the plaintiff side has some of the preeminent plaintiffs' law firms in the Midwest and maybe in the country that are on this case. All of us who have tried cases know there's always something. You know, right now, everybody sitting in this room and all lawyers who are online could say with 85, at least 85% degree certainty, what the proofs are, how they're going to come in, what the people are going to say. And probably closer to 92.5%. It's, I mean, there are not going to be surprises here. I wouldn't think. That being said, it's certainly not unusual in a complex criminal prosecution or the prosecution of a civil claim and the defense of a civil claim, where as you get closer to trial, you're done with sort of the motions in limine, you've done the trial briefs. Oh my gosh, we got to try to get this one document. I mean, it happens all the time. And I hear loud and clear what you're saying, Mr. Gamble, and I agree with you. We got to get to what is it? What are we trying? What are the documents? Everything else. I guess my response, Ms. Alma is as follows. I've issued my orders. I stand by my orders, but I've also sat in your chairs for 17 years before I took the bench. I get that there might be some exceptions. Let's get the things in our final format as quickly as is humanly possible, and let's understand what the road marks are going to be in this journey we're going to take together. And it means you need to get your exhibits to list. And I appreciate everybody's working hard. I fully appreciate Hanukkah is coming. Christmas is coming, Kwanzaa is coming, the New Year's is coming. Hopefully a closing push to the playoffs for the Lions is coming. You know, lots of good things are happening in the next 45 days. But you know, we've been 5.5 years. We need to get going, and I know everybody's working hard too. So, but I'm not gonna make a declaration. This is coming in, this is not coming in. I'm not doing that right now, but really, we all need to move that way. Mr. Gamble.
If I may, thank you, Your Honor. The court's existing orders already planned for that contingency, because what the court said is they have to get us, based on the representations they made last time they were here, they have to get us their actual exhibits by November 19th. And then the court said December 5th, which is today, is plaintiff's last opportunity to highlight and provide copies of exhibits that they realized that they needed.
Okay.
And that's
now-
it. And I mean, that's the written order.
Yep.
And so we do not agree to continue to extend that date. So,
To the extent you are interposing an objection, the objection is respectfully overruled. You've got 1 week to get it done. Okay,
Thank you, Your Honor.
thank you.
Your Honor,
Yes.
it would be helpful for us if we knew what is going to be done in the next week.
Well, one thing, today is our day to provide you, another witness exhibit list and our exhibit.
Solomon Road,
I'm sorry.
I know your throat is,
Sorry, am I
yeah,
going in
just
here?
if you could share your,
Yeah, I'm sorry, I apologize, because I'm looking at Mr. Gamble instead of addressing the court.
no, that's fine.
Anyways, today is the due date for us to provide our exhibit list again, and we are going to be providing it. You have until next Friday to tell us what you'll stipulate to. So if there's some things you don't stipulate to, we may need to have a custodial deposition, for example, on, for these third parties. And,
Who? What third party? Who are you referring to?
maybe, TerraSense, Somatech. Somatech, it's one of the engineering firms. Other one I can think of is Mill Road Engineering. I'm not sure we're subpoenaing them, but those examples.
Okay, just,
Okay.
let us know who they are. I
But
mean,
your honor's representation, I think I'm on. I think would alleviate all those, would they not, Ms. Almanor?
Not necessarily.
Oh,
Yeah,
It likely does, but not necessarily. We shouldn't make the
I mean,
commitment.
if in the meeting, we've been in an extensive meeting for process, as you can imagine with
I'm
the
sure.
defense.
I'm sure.
And if we are at the point now where the proposed stipulations of fact have been tendered, we're waiting for their responses. And I think what Ms. Almanor points out is a viable, or is a possibility that for whatever reason, authenticity is challenged or a custodian is going to be demanded, and we don't know that yet.
Right.
Barring that, though, Your Honor, I think as long as, the large part of the exercise for us was going to have to be to run down all of the labs, and all of the soil testing for the IFT. And that's, if Your Honor's order comes out as indicated today, that's going to be mooted.
Right. Mr. Gamble.
I understand the court's ruling. Court's already overruled my objection. So.
Okay. Thank you. Okay. Thank you. Anything else from the plaintiffs before we give the defense the opportunity to share whatever thoughts they might have?
Nothing further.
Nothing from class.
Counsel.
Your Honor, you had asked, this is Nathan Gamble for the defendants. You had asked about witness lists,
Mhm.
and our intention was to provide that with the pretrial statement, which is due next week.
Okay,
So that's all.
that's fine. Plaintiff said we'll do that.
Yes, we will, Your Honor.
How much of a burden would it be, Mr. Gamble, for you to just spitball amount of time? And I don't if you want to wait till January 5th, that's fine. And we can do it then. I mean,
I think we need to wait till January 5th.
everybody's got a lot going.
Your Honor, as illustrated by just the past 5 minutes,
Yeah.
things constantly are changing over here.
Yes.
So
It's the nature of life, Mr.
Uh-huh.
Gamble. Wait till you're my age. And as my wife and I say, or I say to my wife, the days seem to go slow, but the years certainly seem to go fast. So we'll catch up with you one of these days. You're still quite young, Mr. Gamble. Okay, that's
Probably
fine.
not as young as I look possibly, but
The cheat is for lawyers is the P number. So, you get mine's a 38, so everybody knows I'm a fossil, but I don't know, what's yours, 70 something?
75.
Yeah, how did I know?
Relatively speaking, Your Honor. So
Okay. I think Mr. Pitts may be the only one in the case that has a P number that's lower than mine.
Your Honor, was it assigned after you got barred? In other words, was it alphabetical for you?
That is a really good question. It's by date of admission. And so if you look at the admittees from the July 1985 bar exam, my P number is like at the end. So everybody, oh, he had to petition. No, I did not. I was on active duty. And back then you had to come back to the state. And so I took a couple of days of leave from where I was stationed, came home. I was a law clerk at Bushnell Gage Doctoroff in Risen. So I asked if Judge Hilda Gage would administer the oath or do the oath for me, and she agreed to. And so mine's a little bit higher than most of my colleagues. I swear I passed on the first try. So yeah, how about yours?
Yeah, well, I was 1992, so at that point we were well into it. My father is a lawyer also, though, and he had, I don't think, I'm accurate. I don't think that when he got barred, they had P numbers.
So is he a 1-0?
Yeah, something.
Yeah. So those, the P numbers that start with a 1-0, there's no correlation with age, but because they started at 10,001, I think. And then I think those first admittees were all alphabetical, is
yeah.
my understanding.
Yeah.
Back when I read for the law with President Lincoln, it was very interesting. So, all right. Okay, so witnesses, thank you, Mr. Gamble. That's very helpful for me to understand. I don't remember whether I saw emails or letters or something. It was about in person, not in person. And just sort of globally, expert witnesses really, absent something unexpected and exceptional, my expectation is they're in the courtroom for their testimony. My preference is everybody else also, but I also understand if if we have custodial witnesses, if you want to do them by Zoom, I have no problem with that. But as far as substantive witnesses on the essential issues that the court is going to have to decide, it would be very helpful if the witnesses were present. If you are unable, I know if you're unable to make that happen, I want to be able to talk about that. Just be ready to talk about it on January 5th. And that, my understanding, is going to be a Zoom conference. So,
Your Honor, we may have one of those issues brewing, and I'm a little unclear on it to the full extent, but we have a witness named D. Perkypile who was subpoenaed to testify last Thursday. That was adjourned without explanation. It's now rescheduled for this coming Wednesday.
okay.
A stipulation was entered yesterday that we were not a party to and we were not even aware of between counsel for the state and counsel for Mr. Perkypile, indicating that they will only be asking him questions about facts. The word facts is doing a lot of work in that statement. I don't know what they mean by facts and what the scope of this deposition is going to be. But this is going to be a Debene essay deposition, presumably preserved by video to be played at trial. And at a minimum, we need to know the scope and whether that's going to be allowed to be played so we can not be taken by surprise and know what the scope of our cross-examination is going to be allowable to be.
And Mr. Perkypile is an engineer. That's the kind of context of it all. It's not a lay witness.
Your Honor, Richard Cole. Yeah, sorry, I explained to other plaintiffs' counsel today what was going on, but.
Why don't you just hum a few bars so that I can sing it to
Absolutely.
myself?
Mr. Perkypile is an engineer. He lives in Arkansas, so we had to go through the process of subpoenaing him. He retained a Michigan lawyer who objected to.
What's the gentleman's name?
Mr. Perky Pile.
Perk,
Like turkey with pile on the end.
oh, okay, Perky Pile.
Spartan
Okay,
with a P, yeah.
good.
And they objected to our taking a deposition of Mr. Perky Pile, but they
They being
agreed,
who?
Mr. Perky Pile's attorney.
Outside counsel.
Yes,
Nobody in this case.
correct.
All right.
But they did agree that if we were solely to ask him about factual issues and not opinions that he had reached, that they would permit the deposition. We didn't have a problem with that, so we've agreed solely on our behalf with their counsel that we will limit our questions to factual. We have made it clear to Mr. Perkypile's attorneys that we cannot agree to such a limitation on behalf of the plaintiffs, and they're free to make any objections or to take any actions necessary.
Who's Mr. Perky Pile's attorney? Michigan attorney? I assume is it a Michigan lawyer?
It is a Michigan lawyer, and I can't recall her name off
May
the top of my
remember.
head. It was a smaller firm. Oh, I believe her name is Rana Lang,
Last name again?
Lange.
Okay. Where? From what life experience does Mr. Perky Pile have to provide information which is relevant to the case?
He was a consultant retained by FERC. No.
Mr. Perky Pile was hired by Boyce Hydro to be their dam safety engineer. He continued in that function for many years, including after the revocation of the license. So he has factual information related to, he, for example, is the person who prepared the 2015 independent safety report. And he performed the gate testing that the plaintiffs have highlighted many times in their briefing. So he's not our retained expert. We haven't identified him as an expert. I don't think the plaintiffs have either. The fact that he's an engineer is just that. It doesn't mean he's an expert witness here. And so we've already explained to him that we don't intend to make him an expert witness, and that's what his attorney was concerned about. So we're asking him factual information about what he knew and his involvement. So.
Okay. Anything else on that, Mr. Perky Pile?
No, we did provide an explanation for
Right.
why he was
Okay,
rescheduled.
good.
That's
Thanks. Plaintiffs, does that,
A little bit, Your Honor. I mean, I guess listen, like you were saying earlier, as trial attorneys, we have to be comfortable with a little bit of ambiguity, and I always am comfortable with a fair amount of ambiguity. I would like less surprise if possible.
right?
I'm concerned about a potentially very broad definition of the phrase factual information. And I guess we'll figure out what that means. It's the eye of the beholder, and right now the beholder is Mr. Gamble. So.
Well, Your Honor, I think that's incorrect. As we've made clear to the plaintiffs, none of our agreements are binding on plaintiffs. So plaintiffs shouldn't have anything to worry about going into the deposition. They've retained fully all of their rights.
Thank you both. The record will speak for itself. Should there come a time where we need trial court intervention. So this can be a Debene essay next Wednesday?
Yes, Your Honor, on December 10th.
Video or remote, or I guess everybody does everything remote now.
It
What's
will,
the-
it will be video. He's in Arkansas, so that's why it needs to be.
And then who, what, who or how many, what would, sorry. Who's going to appear for the state? Who's going to appear for the plaintiffs?
I'll examine Mr. Perky Pile for the defendants.
All right? Do we
Yeah,
know?
there will be attorneys for mass and class on the plaintiff side. I will be conducting the deposition on behalf of all plaintiffs, though.
Let me have a second. What time is this deposition set to go?
10 o'clock a.m. Eastern.
Is Attorney Lang going to be present?
Yes, she will, Your Honor.
what I've been. Okay, 10 o'clock. On the 10th, right?
Yes, that's correct.
The best of either side of the cases, lawyers. It's your understanding, is it everybody's understanding Ms. Lang is a licensed attorney in the state of Michigan?
Yes, yes, she is. That's my understanding. She's in Novi.
We have no idea.
Okay. All right. I'm reticent to do this, but I'm going to do it. I've just entered on my calendar. Well, I spelled deposition incorrectly, not a surprise to anyone who knows me or any of my grade school Immaculate Heart of Mary nuns who taught me, or the congregation of St. Basil priests who taught me in high school. I misspelled deposition, of course. But I've entered deposition, Mr. Percopile in Arkansas for Edenville case, 10 a.m. to 11:30 a.m. Why am I telling you that? I'm telling you that because if you have a problem, get a hold of my staff. I will make myself available. We need to have the court reporter prepared to have me on the record and have a session of the court during this DeBene essay deposition. I really hope that is not necessary. But, and you can let Ms. Lang know that the court has represented in open court on the record to both parties that I'm making myself available to participate if need be. I really hope that's not necessary. But I don't want us, I don't want a witness out of state's issues or their, anyway, that, but if both sides would prefer that I not, I won't make myself available.
No, this is Nathan Gamble for the defendants. No, we're happy to have the court available. We have no problem with that at all. And we would, like you, hope that that isn't necessary. We don't anticipate this being controversial deposition at all. But
I just don't know. I don't know the counsel. So it's, anyway, do the plaintiffs have any objection to the court making itself available?
No, Your Honor, we appreciate it and we will not call
I know you're not gonna
we're not going
loosely
to call the
call.
court lightly. It's only
Right.
if it's an absolute necessity.
You
So
have Mrs. Thomas' direct number, I think. Is that right?
we have her direct email, Your Honor. And we,
Okay, so when we're done, Mr. Gamble, if you could send an email with either Ms. Almarad or whoever the quarterback is for discovery for the plaintiffs, send an email to Mrs. Thomas, say, the judge said he's going to make himself available. I'll tell her, so it won't be a surprise. We would like a number where we can reach you on Thursday if we need to get a hold of the court right away. And I'll ask her to give you, I'm not sure which number she'll give you, but if it is her personal cell phone, I'm instructing the parties not to obviously circulate that. If it's just the desk phone, that's in the state bar directory, but I mean, we all understand that. So,
yeah, yes, Your Honor, we'll do that. Yeah, we'll email Ms. Thomas.
all right, thank you. Is that okay, Ms. Almarad? All right. Okay, what else?
that's it, Your Honor. Thank you.
Ms. Husa, anything else we need to address with our council before we wish them happy holidays? All right. Council, let's all spend some time with doing the things we like and with the people and pets that we love between now and January 12th, because I think we're going to be seeing a lot of, not that I don't really think all of you are great, but I probably would prefer to spend time with my granddaughters than presiding. But this is a serious matter for both sides of the V thousands of plaintiffs, 2 departments, agencies. It impacts a lot of things and people. So I appreciate everyone's hard work. I know that you're going to be working hard over the holidays. I'm sorry for that. I have case call in Detroit the week before, and I just got my January assignment of 25 cases I get ready for the previous week. So I think I finished those, and then I'm back here for our status conference. I should actually look while we're all here. Oh, no, the status conference is Monday, the 5th, and then case call is the 6th and the 7th, and then we start our trial on the 12th. I will also indicate for the record, one final thing. This is related to the motions that I've preliminarily indicated where I anticipate I'm going to rule. I understand every party has a right to seek interlocutory review, and I respect that immensely. I will say on the record, if I rule as I do, as I have indicated, in the event that a non-prevailing party, either individually or even stipulated to, wishes to seek interlocutory review and a stay of the proceedings, the court would, if such a motion were made, would respectfully deny any request for a stay or any request for a stay. The reason is the events giving rise to this matter took place in May of 2020. We are over 5.5 years after it. Everyone is ready to try this case. These very good lawyers, the court staff. I cannot envision that I would grant a stay. That does not mean that the parties cannot file an immediate motion for interlocutory review once my opinion order is released. But I want, when the Court of Appeals is being asked, did you ask for a stay? I'm assuming both parties asked for a stay that didn't win. And I'm saying right now, I would, if such motions were made following my release of my opinion order, I will deny those because this case needs to be tried. I'm doing my best to keep the errors that I commit as limited as possible. I'm certain I've committed errors because I'm an imperfect person, very imperfect lawyer and imperfect judge, but I'm trying to apply the law fairly and equally to both sides. All of these matters are weight, not admissibility issues in the court's estimation. And I look forward to the privilege of continuing to serve in the case January 5th and then January 12th as we commence the actual substantive trial on liability. But I just this week, I think it was on Tuesday, I opened my email up and I got all these orders from the Court of Appeals. I'm like, what am I getting orders from the Court of Appeals on? And I opened one, David Krieger versus, oh, okay. And it was the Court of Appeals saying they weren't going to stay the case and grant interlocutory review at that stage. Doesn't mean they won't do it next week, but then every single case, I must have had 25 orders. I was like, what have I done? Oh my God. So anyway, I'm not saying that to be mean or to be rude, but I want this thing as ready to go. And if somebody feels like they need to appeal, I want them to be able to do it right away. I will probably incorporate just a sentence at the end of the opinion and order, if it comes out the way I think it's going to, that says the court, anticipating that a party who is non-prevailing on any of these may wish to stay and have an interlocutory appeal, the court will respectfully deny that. I'll incorporate that so you can have a solid order to ask the Court of Appeals to stop the case. So And then if that happens, then everybody's January become a little more wide open, I would suspect. So. but- All right. Dan, anything else? Anything logistically that the lawyers need to hear from you on? No, 5th is video. You're good? Okay. Elizabeth, you're good? One last opportunity, plaintiffs, anything?
Nothing further, Your Honor.
Nothing from class.
All right, defense.
Nothing from defendants, Your Honor.
All right, thank you. Today, it is now 11:30. The court is in recess. Have a nice day.
Thank you.
Happy holidays to everybody. Yeah, thank you.